and high quality so that it allows students to obtain a high quality education. There's a balancing that has to go on, that the commissioner has to bear the heavy burden to deal with, a balancing between safety and a balancing between high quality, a balancing between protecting the students and protecting the teachers and protecting the staff and the community and providing that high quality education. Emergency Order 6 was an answer to two separate pleas, two separate sets of prayers, one by parents who were frustrated and frightened by what happened in the second quarter with virtual education. I don't think anybody disagrees in this case. The plaintiffs have admitted it in their pleadings and in at least one of their affidavits that virtual education is no substitution for education in person. We end up with missing students. We end up with folks with individual learning programs that suffer, English language folks that suffer, the financially disadvantaged that suffer. And EO6 gives all parents that choice. One of the purposes of EO6, and it's set forth right in the front, and nobody's going to run from that on the side of either the governor or the commissioner, but one of the purposes was to see to it that there would be a reopening of brick and mortar schools with full services parents could choose from. And that is certainly one of the things that it does. It provides for that choice. It provides that at pages 1 and 3 of the order. But the other thing that emergency order dealt with, and I think as we talk about this today, Your Honor, you're going to see that it's an irony that infects the entire case and demonstrates that the plaintiffs can't really get the relief that they want. Prior to the entry of this emergency order, what the school boards faced, what the superintendents faced was the existing legislative framework for how schools are compensated for educating. It wasn't an issue at the second quarter of last year, the 2019-2020 year. And it wasn't because the calculations for how you're compensated are done in October and February. So in October of 2019 and February of 2020, you take your census that tells you how much you get paid for students in the seat, and to the extent that you had virtual students back there, how you're paid. Superintendents looking forward were concerned that if we give parents the choice, if they're not simply required to be back in school, that parents might very well choose not to have their students in there. And we've seen that played out across the state as reflected in the pleadings, at different levels. In some districts, more parents than in other districts. But the concern was, okay, if we apply the standard state funding, and the plaintiffs have alleged this in their complaint, it's about 25% more if you actually have students there full-time in their seats. And I'm sure there are a lot of reasons that the legislature has come up with funding it that way, but it's 25% more than you would get for students attending remotely. In addition, when you get paid is different because the remote teaching is done upon completion, so you can understand the impact. The superintendents were concerned about that, and Emergency Order 6 dealt with that by waiving various of the statutes and regulations. How can the Commissioner of Education waive the statutes and regulations? He can do it because the governor is granted emergency authority by our legislature. He's granted the authority when we have something like coronavirus to step up and say, this is an emergency, and he can grant or delegate to various of the cabinet officers, people like the Commissioner of Education, the ability to waive some of the educational statutes where it's important. And for example, if you look at page 2 and 3 of the executive order, they waive strict compliance regarding establishing a uniform and fixed date, having to be open 180 days, when you start and when you're finished. And most important for this case, it provided at, excuse me, Your Honor, page 6 under reporting flexibility and financial continuity, it basically said, look, if you submit a plan under Executive Order 6 and that plan is approved, and you go forward and you provide options to all parents to either be there, the students rather, to be there face-to-face, to be there remote, to be there virtually, then we will waive the requirements that you have your students in the seats in October and February. We'll treat them as if they were actually there. It would provide more dollars for safety, more dollars for teachers, and it would alleviate the superintendent's concern that if you had counties with significant absences, significant number of students either appearing in their classroom remotely from home or in a virtual high school, that they would suffer and they would not have money. They'd have to fire teachers, let go staff, forego some of the things they would do. It left safety locally. If you look at the plan at pages 2 and 3, certainly says that ultimately safety decisions have to be done locally. And importantly, Your Honor, for the purposes of this case, critically, at page 6, right before Roman numeral 3, says nothing herein requires a district or a charter school to submit a plan if the district or charter school wishes to open in traditional compliance with statutory requirements for instructional days and hours. So no school district, no school superintendent was required to submit that plan. Now, and as plaintiffs will talk about, and we'll talk about later in the case, they argue that financial incentive simply removes the choice. We disagree with that and don't think that that is a question that can be answered here. One county, Charlotte, did choose that they were simply just going to do it the regular way, and they've submitted a plan outside of emergency order 6. So what happened with the plaintiffs, excuse me, parents chose that 54% of the students will be attending in school. 1.6 million students have been signed up to appear. Some are already in classes, some are planning to be there. Obviously, the school superintendents and the school districts have been spending the time, energy, and effort necessary in July and in August to be prepared to have those 1.6 million students there. Plaintiffs here say that what we should do is declare emergency order 6 unconstitutional, either because it violates Article 9 or because it violates Article 9's requirement for safety, or because it is arbitrary and capricious. The relief that has been sought is telling, particularly in light of some of the comments yesterday, and hopefully I have my colleague available to put up the one slide that we have here that lays out and juxtaposes the relief asked by the Orange County plaintiffs and by the plaintiffs in Miami. So Nate, can you put that up?
Your Honor, can you enable us to be able to share screen?
And I'll tell you that this is the only one we're doing. We don't have any PowerPoints or things like that, but I thought it was important to put this up.
I believe the court has to enable us to do it. It's currently blocked.
You are enabled.
We are now enabled. Okay, thank you.
Perfect.
Okay, the first one is from the Miami case and setting forth the relief that's been requested, and it's an order enjoining all the defendants from unnecessarily and unconstitutionally forcing millions of public school students and employees to report. An order requiring the defendants to develop and implement an online instruction plan aimed at all children and to make internet connectivity and computer devices available to all students. So an injunction to prevent the schools from opening, an injunction directing that the Commissioner of Education provide the funding necessary to internet connectivity and computer devices, and an order that before any physical reopening, the court would direct, I guess, the Commissioner of Education to provide the funding to have the various items set forth in paragraph C. Nate, can you go to the Orange County one, please? And the Orange County prayer for relief, a preliminary injunction enjoining defendants from opening public schools in Orange County until such time as they can demonstrate to the court that the schools are safe, asking that the schools not open, or presumably the schools that are already open, close and stay that way until there's some form of a hearing in front of the court to determine which of any of the 4,000 schools can be opened. Injunctive relief from the court to order the governor to not reopen schools, as it does not meet the fundamental principle to protect citizens. Injunctive relief from the court to order the governor and appropriate government agents not to restrict state funds to the Orange County public schools should they refuse to permit face-to-face education. And we'll talk about that in a minute, because that's a misnomer. It wouldn't be to stop or restrict them from funds. It would be requiring the commissioner to waive the current statutes not to provide funding. It'd be asking the court to say to the commissioner exercising his authority under the emergency order of the governor to make this funding. You can take the slides down, Nate. Thank you. So let's turn first to the standing issue, Your Honor, and there are two pieces to it. One's a bit easier than the other. There are parent plaintiffs in this case. The parent plaintiffs can't possibly have standing because the entire purpose of the emergency order and the way each and every one of these plans has worked is the parents have the absolute choice whether their student goes or their student doesn't go. They're not being forced to anything. 1 million, well, a lot more parents than that, but the parents of 1,600,000 students have decided they want to go. Roughly 1,000,004 have decided they don't want to go. So they've got the choice, and the parents that have brought these suits have the choice to either have their student appear remotely in their home high school or through the individual district's virtual school. So they can't have standing. The teachers and the teachers union is a little bit of a different argument, but here again, this order does not require any teacher to do anything. That's left at the district level, at the 67 districts, as to who is going to be there, who is not going to be there. They have contracts with those school districts, contracts negotiated by the underlying unions under the FEA that have negotiated that have provisions in there that entitle them to relief. And in fact, there's two separate lawsuits going now on that issue. One of them arguing that there's already a grievance in Orange County and that there's an arbitration to be had to make those decisions. So no teacher is forced to show they have the ability to stay home. That does leave them with a cause of action under their contract to be compensated, but they're not being required to go. Let me turn to what I think is while standing is a strong and powerful argument, I think there's an overarching argument here that just demonstrates that we shouldn't be here. We shouldn't be having this argument here. It should be playing out in a different venue. And that is, it's absolutely crystal clear under the Florida Constitution and under the law that the Supreme Court has laid out for us that the separation of powers between the executive, the legislative, and the judicial branches have to be adhered to strictly. And the court can't be driven to invade that separation of powers or to answer a political question. And the two of them typically go together. We've cited, Your Honor, the case of Orr versus Trask in the Supreme Court from 1985 that talked about how the court should be wary of interfering with the constitutional authority and responsibility of Florida's governor after a long soliloquy on the respect for the equal branches. And here, if you think about what's being attacked is the emergency order issued under the authority of the governor of Florida to deal with emergencies such as coronavirus, to make the difficult decisions that executives have to do, to, among other things, delegate those decisions to its officers, such as Commissioner Corcoran, to make those tough choices on how do we balance, how do we deal with the undisputed need of students to be back in school, particularly students endangered at home, students compromised by an inability to learn as well over the internet, students who have language issues, and students who need individual programs, and just your average everyday student. The CDC has made clear, and the papers cited by plaintiff psychiatrists, or psychologists, forgive me, have made clear that there is a significant loss of those students when they have virtual education. And those are the competing interests that the commissioner has tried to balance fairly and appropriately as an executive with respect to the emergency order. The relief requested that we've just walked through clearly requires the court to invade the separation of powers, or to breach the separation of powers, and answer a political question. Let's take it as it's, I think, first laid out and still laid out in the complaint, which is the concept that this court would either enjoin, would enter an injunction that in some fashion stop the schools from opening and close the existing schools. That clearly is something to be done through the Department of Education, working in conjunction with the superintendents, and is not something within the realm of the judiciary. The concept that the court would be asked to direct that money be funded, that appropriations be made, that they're talking about here, is clearly not something that be done without violating the separation of powers and answering a political question, answering the question of when 4,000 schools were open or reopened. That, I think, is an impossible argument for the plaintiffs to make to get around that. They've made a course shift, I think, although in fairness, it's loosely referred to in the complaint, so we certainly can't cry foul. But the new cry is free the school board, free the school superintendents. Just let my people go so that they can decide on their own whether or not the schools open. Put aside the fact that Emergency Order 6 is not mandatory. It absolutely says, as we just went over, that school districts have the choice to participate or not participate. And it also says that on a school by school basis, that if local issues require, the superintendents have the ability to make those decisions to protect the safety of the students. They've got to make them in conjunction with the commissioner. They've got to comply with their plan, but they have authority with those, within those constraints, to do that. But the bigger problem for that, even if you accept the premise that, oh no, these superintendents really don't have the right to do it, and if you accept the argument, which I'll address in a few minutes, that the Commissioner of Education has no say in this matter, no ability to have a seat at the table over whether they open or close, that is constitutionally separated and put into the hands of the superintendents, with which we disagree. They have a bigger fundamental problem. At the end of the day, this becomes a fight over not a fight over nothing. It's a fight over very important issues, but it becomes a fight that doesn't give them the relief that they say they want and need, because the plaintiffs have been candid. They candid in their response to the motion to dismiss, and yesterday, that they are not satisfied, will not be satisfied, and cannot be satisfied with an order that simply declares Emergency Order 6 null and void, that simply says to the superintendents, you may act as if there never was an Emergency Order 6. You decide on your own, without regard to any plan that you have submitted, when you're going to open, when you're going to close, and how you're going to do that. That does not satisfy the plaintiffs. The plaintiffs have made it clear that they need your honor to also order that the Commissioner of Education, once this emergency order is validated, go ahead and waive these statutes. Waive the statutes in order that schools receive appropriations not in accordance with the current statutory framework or regulatory framework, but using his emergency power, say that we will go ahead and we will fund students as if they were all in the seats, leaving, frankly, superintendents subject to incredible attack afterwards by these same unions that are already bringing lawsuits to be able to say, wait a minute, you can't open these schools. You have no excuse not to open these schools. Opening these schools is inappropriate and bring the bully pulpit pressure to bear on them not to open. But they can only do that, Your Honor, if they can convince this court that you can step into the role of the Commissioner of Education operating under the governor's emergency orders and cause these appropriations to come about. And the case law, and we'll talk about citizens in a moment, is incredibly clear on that point. Before we get there, we submitted in response to some of the things said yesterday, a short reply that talks about the emergency powers, talks about the rights of the governor in terms of an emergency to authorize the Commissioner of Education to take such steps. The governor's already been sued over whether beaches should be open, and whether he's exercised his emergency power properly there, over whether people should or shouldn't be forced to wear face masks. We've submitted those cases attached to our reply, and every one of them has found that it's a political question, number one, and number two, when you're acting in this arena in an emergency, there is additional deference. There's deference to the executives that are having to carry the heavy weight of making these decisions under their authority in an emergency. But let's talk about, I think, the one case, Your Honor, the one case that clearly directs what needs to be done here. It's been talked about by both the plaintiffs and the defendants. It's get the right complete title: Citizens for Strong Schools versus the Florida State Board of Education and a large number of people. It was tried in Leon County, went up to the First District Court of Appeals at 232 Southern 3rd, 1163, and then to the Supreme Court. And citizens were arguing under Article 9 that we did not have adequate schools for an entire litany of reasons, and it went on for a significant period of time. The state defendants argued throughout that this was a political question, making the determinations of what to spend, how to spend, where to spend, what would be an adequate and appropriate education was the quintessential political question. But nevertheless, the court went ahead and let it go to trial. And then at the end of the day, in addition to ruling against the plaintiffs on various grounds, said it's a political question. So after a complete trial, found that there was a political question. There are sections of citizens that I think are particularly telling here. First, the court made very clear that when you're talking about the authority, the decisions made under Article 9 with respect to where money goes, how it's paid, how those balancing decisions are made in order to put together a proper school system, that the Department of Education has great latitude. They get to make those decisions. The court doesn't get to strike that. Plaintiffs don't get to come in and second guess it by bringing in a slew of experts to say it should be done differently. And there's one section, two sections actually, I'd like to just read and have there, because one is particularly telling. In talking about education, the First District said the most effective manner in which to teach students science, mathematics, history, language, culture, classics, economics, trade skills, poetry, literature, and civic virtue have been debated since at least the time of ancient Greece. And they go on to say, in a republican form of government founded on democratic rule, it must be the elected representatives and executives who make the difficult and profound decisions regarding how our children to be educated, and absent specific and clear direction to the contrary in the supreme organic law, which does not exist in Article 9, Section 1A of the Florida Constitution, we uphold the trial court's ruling that such decisions are not subject to judicial oversight. Well, as I read that and I thought about the fact that they've debated education since ancient Greece, I wondered how many centuries they'll debate how one deals with something like coronavirus, the debate that has raged across not just this country, but this entire world over what's the right way, who's right, who's wrong, what's the proper data, what's the right way to do it, has been amazing. You've got doctors on both sides, you've got public officials on both sides, all arguing that their way is right, all arguing and making these tough policy decisions. And we've seen them played out differently over the 50 states in this country as to how that's been done. I can't think of a greater political question or a greater policy issue than how one goes about doing that.
Well,
Now-
didn't though, in that very well written final judgment by my former colleague, now retired Judge Reynolds, he states in that case, though, even though he found for the state in that case, he said, however, it cannot be said that every education issue is debatable. And both in Judge Reynolds' order and in the first DCA's order, the courts are talking about what are judicially manageable standards. Judge Reynolds said the terms in Article 9 relating to safe and secure are subject to judicially manageable standards. This court believes that the terms safe and secure are different from the terms efficient and high quality. Judge Reynolds wrote, Florida's trial courts deal with issues related to safety and security all day long. Allegations of unsafe or unsecure schools can be measured differently and more definitively than can terms like efficient and high quality. And the first DCA, I read that case several times again before today's hearing, and the first DCA was focusing on what is a judicially manageable standard. And as stated by the first DCA in footnote 3, they said, we're not going to get into safe and secure and whether that's judicially manageable because we don't have to in this case, and left that as an open question. And as I read those cases, they're saying that if something is judicially manageable, and Judge Reynolds found that safe and secure were judicially manageable, if those are judicially manageable, then we don't get into a separation of powers issue. And if we're dealing with other items that are not judicially manageable, then we get into a separation of powers issue. So I don't think the safe and secure words in Article 9, Section 1 were actually addressed by the first DCA or the Supreme Court in those cases, as I read them. Do you disagree with that, Mr. Wells?
No, Your Honor, not at all. I mean, you asked a great question just as I was getting to talking about the plaintiff's view on the first district opinion and the trial court. And absolutely, there's no question that what Judge Reynolds said was, when I'm looking at adequate, when I'm looking at quality, I don't have anything that I can go and look to. I think what we have to do, though, is look at what was the safety issue that Judge Reynolds was looking at. He was not looking at an amorphous mass of competing data and science over something like the coronavirus. No, the arguments there wasn't enough money to make sure that the buildings were up to building code, that they had been properly maintained. And if you go on in his opinion, you'll read where he says, we've got the building code. We can look at the building code and decide whether or not, School 101 meets the building code or not. There's not an issue there. There's nothing there for debate. I would submit, Your Honor, that the concept of what's the right decision with respect to coronavirus is a different type of safety issue. It's not a type of safety issue where, for example, in Dunkin' Donuts case, you could look at the building code, a case that was cited where a franchisee was being held to account by Dunkin' Donuts, cited by the plaintiffs over whether or not it met the sanitation standards. I think that what the court found there, although they didn't begin to talk about political question because no one would raise it in that context, was, obviously I've got standards. That's different here. And Judge Reynolds, in looking at this, I don't think was making a decision that, irrespective of whatever the safety issue might be or other issues under Article 9, that there would be meaningful standards. I think he left open, as frankly the Supreme Court left open in the affirmation of the first DCA, that there may very well be standards, but there's not a standard here. You only need look at even the materials put together by the plaintiffs in terms of the varying views on what does one do about the coronavirus, what does one do about safety, to know that there is no standard. We would be creating the standard anew in this case. We would be asking this court to create a standard, number one, and then rule how one would make the difficult balancing and policy decision around, do kids go to school? How many of them go to school? How are they treated in school, to protect those that are disadvantaged and have issues against providing for proper protection? And one of the things that these plans have done is to lay out exactly how they're going to go about doing those protections. But there's just no place for the court to go other than a trial on coronavirus to provide some type of standard. There are standards out there about, for example, if one was talking about efficient or high quality in products or construction, there are cases where judges deal with that every day, but they're not looking at what's been done by an executive operating under his powers under the Constitution to do that. He's looking at a particular contract, such as they did in Dunkin' Donuts, or in the ICE case, dealing with a prior ruling about what a prison needed to do not to violate the Eighth Amendment. So I suggest that none of those cases cited by the plaintiffs deal with the issue of political question, because they don't arise there. And both Judge Reynolds' decision, the First District Court of Appeals decision, and the Supreme Court decisions teach that there is a type of question, a type of issue that should be firmly left either with the executive or with the legislative, and dealing with safety in this fashion, particularly when you're being asked to do two things, I think, Your Honor: decide whether or not what the schools are doing is safe going forward, and what time it's to go back. And that's, I just submit, not a issue for the court, but in order to give the plaintiffs what they want. It's even more than that. What they're saying is you have to decide whether certain appropriations should be made and what those appropriations be made for, to be able to provide the relief. And surely the cases that we have cited, and indeed the lengthy discussions in Citizens, the issue of appropriations is particularly an area where the court is constrained from violating the separation of powers and from violating or for answering a political question. Have I answered your question, Your Honor?
Yes, sir. Thanks.
Thank you. So I'm really almost done, Your Honor. I would say that we had one last argument, which deals with an injunction's been asked for here. And the question is not a indispensable party issue. The question is, can a court grant certain relief when stakeholders aren't there? And we've briefed those cases, and plaintiffs don't really deal with those. They talk about the separate issue of indispensable party, and the two are not the same. What has happened here is there is a significant stakeholder, and that stakeholder is the voice of the 1.6 million students, and however many parents that translates to, that have no voice here, no voice in this hearing other than is carried by the Commissioner of Education and the governor. And it's their choice that the union wants to negate, and their voice they want to silence. And I don't believe they can do that without some provision for some type of representation to the 1,600,000 people returning. And I would address one other thought, Your Honor, in terms of the concept of the court trying to step in and answer these political questions and move forward. 1.6 million students are signed up to come back now. The students are prepared to have them come back this way. The union would have you wipe that away and eliminate that choice and send the schools back to scratch on figuring out what to do with these 1.6 million. And we'd have a trial, the whole purpose of which would be to second guess the balancing done by the Commissioner of Education under his statutory powers here, and to have a trial on the right way to deal with coronavirus, which is inherently a political question, Your Honor. We respectfully request that the complaints be dismissed.
Who will be responding for the plaintiffs in these consolidated cases now?
Your Honor, this is Ron Meyer for the FEA plaintiffs. I will be doing the argument, and Mr. Stewart will also respond to the specific allegations that are made in the companion consolidated Orlando case.
Okay, Mr. Meyer, you may proceed.
Your Honor, before I respond to a lot of what my colleague Mr. Wells has raised, let me reiterate where we are in this proceeding. We have a complaint that was filed that makes a number of allegations, and the state has filed a motion to dismiss, not a traditional motion to dismiss for one of the reasons set forth in Rule 1.140, but raising some issues which I guess, if you read them together, suggest a failure to state a cause of action. That's the proceeding we're here on today. The case law, Your Honor, is very clear that the facts in a complaint, when you're gauging it in terms of a motion to dismiss, is as follows. When presented with a motion to dismiss, a trial court is required to treat the factual allegations of the complaint as true and to consider those allegations in the light most favorable to the plaintiffs. So everything in the complaint, for the purposes of this legal analysis you're being asked to make on the motion to dismiss, has got to be considered to be true. Further, the test of the sufficiency of a complaint is not whether the complainant will succeed in obtaining a declaratory decree of rights in accordance with his theory, but rather whether he's entitled to a declaration of the rights at all. And those are the cases we cite in our memorandum. Your Honor, what we heard basically from Mr. Wells would be an argument perhaps on cross motions for summary judgment or judgment on the pleadings or some other legal proceeding, but that's not the case before you today. Now, having said that, I recognize the import of this matter. I recognize that we are pressing forward as fast as we can, and this court has indulged us certainly. And so I think it's fair to perhaps leave the traditional approach to a motion to dismiss and look at other items perhaps. But again, when it comes down to your ruling, Your Honor, the test is here whether this complaint states a cause of action, and many of these other issues which Mr. Wells has raised are for a later day. Let me start with the general backdrop. I don't in my practice get to quote Justice Alito often, but in a recent US Supreme Court case dealing with some pandemic related issues, Calvary Chapel versus Sisolak, decided just last month on July 24th, 2020. Here's what he said. We have a duty to defend the Constitution, and even a public health emergency does not absolve us of that responsibility. He says further, a public health emergency does not give governors and other public officials carte blanche to disregard the Constitution for as long as the medical problem persists. As more medical and scientific evidence becomes available and as states have time to craft policies in light of that evidence, courts should expect policies that more carefully account for constitutional rights. Your Honor, we have a 3-count complaint in the FEA case. The first 2 counts are asking not for the relief that Mr. Wells' colleague put up on the screen, but rather are asking for a declaration of rights from this court that the executive order is arbitrary and capricious and therefore violates Article 1, Section 2 of the Constitution, and that the matter further is that the executive order doesn't properly account for the separation of, not the separation of powers, the powers of the elected school board and the paramount duty of the state to make provision for safe and secure public schools. We're entitled to that declaration, Your Honor. Whether that declaration gives you broad remedies in terms of entering injunctive relief, that's for another day, probably next week. Whether we prevail in the declaration we're asking for, that's for another day and another legal proceeding. What's before you here today, Your Honor, is simply whether the complaint states a cause of action, and I submit to you, it very clearly does. The plaintiffs in this case, in addition to the individual FEA plaintiffs, who are educators who allege that they, as a result of this executive order, are going to be exposed to harm as they return to public schools because of the lack of proper attention being paid to the requirement that there be safe and secure public schools. The plaintiffs in this case are alleging that the executive order, and I think on its very face, and as you listen to Mr. Wells' argument, you can't help but come to the conclusion that the executive or emergency order is nothing if not ambiguous. On one breath, he says that, well, in the fall or in the spring, we were able to have distance learning without affecting the compensation of school districts based upon the funding formula. Now we have an executive order that purports to say to school districts, you can submit a plan, but that plan has to include opening brick and mortar schools 5 days a week in every county of this state, or you won't be given the funding. Your Honor, we're not asking the court to decide any funding issues here. The funding for the 2021 school year has already been appropriated by the legislature. The money's there. The question is, can that money be reasonably utilized to pay for student learning through the use of computers, which, let me emphasize also, there's a distinction between distance learning via computer versus the virtual education program, which is a separate kind of education offered by the state of Florida and carries with it different funding considerations. And so all we're saying is whether the children are seated in their classroom or seated in their home or other location, being instructed by live instruction through internet, the funding shouldn't be a problem. But what we have here is an executive order that basically says you only get funding if you do it my way. We think that's arbitrary and capricious, Your Honor, and we think that we're entitled, based upon the complaint as pled, to have a declaratory judgment issued and determined by Your Honor as to whether we are right. But that's the question before the court today. The other issue that I the reading of your colleague, Judge Reynolds' determination in the Citizens case, I don't know how he could have been more plain. And the fact that the Supreme Court nor the First District disturbed that finding leaves you very well posited, as you initially said in the question you posed to Mr. Wells. Don't you have the legal ability to adjudicate whether a school or a system of schools is operating in a safe manner without violating the principles of separation of power? And of course you do. Your Honor, Judge Reynolds said it, common sense says it. Is it a difficult decision you may be called upon to make? You betcha. You have the unfortunate obligation to look at the evidence and weigh the experts and weigh the testimony and make a determination of whether schools under this executive order will be opened in a safe and secure manner. And if not, the executive order should not be enforced, Your Honor. The fact that those decisions may be difficult decisions are nonetheless decisions that this court wrestles with all the time. You make life or death decisions very often, and the ability to determine based upon a presentation of evidence in an appropriate trial is something that you are very well capable of determining. So, I'm not sure why there's even a question being raised about that, and that's what we ask for in two of our counts, is a declaration that the schools are operating in a fashion that's unsafe under this executive order, and that the executive order is all over the place and is arbitrary and capricious in terms of what it does and doesn't do, how it says in one breath school districts should be given the authority to make these decisions based upon advice from medical authorities, and then in the next breath be told that if you do that, you don't get funding, even though the commissioner has, as demonstrated here, the broad authority under the emergency order to waive compliance with some of these funding statutes. He wants it both ways. He waived compliance in the spring. He doesn't want to waive compliance in the fall. And he's willing to put the plaintiffs in this case and the children who are attending brick and mortar schools in potential danger just in order to get his way to open schools 5 days a week.
What about the issue of standing in this case now?
Your Honor, we believe that the individual plaintiffs and the 140,000 teachers who are directly and immediately impacted by the decision that they, in order to keep their career, must present to brick and mortar schools that are operating in a fashion that is unsafe, clearly provides legal standing. This is not just simply an esoteric question that a disinterested citizen is asking whether the court should adjudicate these issues. These people, as we referenced yesterday, are leaving their professions. They're being asked to staff brick and mortar schools in conditions which are unsafe. We can perceive of no more direct and immediate harm. And the association standing rights of the Florida Education Association are well demonstrated. The FEA has the legal right to represent and advance the interests of the 140,000 members of it, who are going to have to choose under this arbitrary order either to pursue their careers or subject themselves to the danger that's inherent in schools which may be operating unsafely, or to leave their career and leave their profession. They shouldn't be in that position, but they clearly have the immediate direct impact and standing to bring this action, Your Honor. Let me say before I invite Mr. Stewart to comment, this is not about separation of powers. We recognize the court's role, we recognize the executive branch's role, we recognize the legislative branch's role. And we're not asking you to encroach upon any. We're not asking you to take over the operation of public schools. We're not asking you to provide funding for public schools or to direct how funding has to be expended. What we're asking, though, Your Honor, is for you to look at the Constitution and make a determination that the arbitrary and capricious way in which this funding is being expended under the order is unconstitutional. We're asking you to find that the state defendants have not carried out their obligation to provide a safe and secure public school setting. And we believe that the complaint adequately frames those questions and brings it before you. I think I'll ask Mr. Stewart to step in at this point on his case, and then I'll be happy to answer any further questions the court has.
Mr. Stewart.
Thank you, Mr. Meyer, and thank you, Your Honor. simply put, I don't want to duplicate what Mr. Meyer said, because he did a good job of summing up a lot of the issues that are correlating between both of our complaints. But I think it's important, Judge, to remember that based upon Florida Statute 86, so I was looking up, .11, a motion to dismiss is not a proper remedy for dismissing a motion or a complaint for declaratory judgment. Mr. Meyer brought that to your attention, but I want to make sure that's clear. Also, Your Honor, from our perspective, within the four corners of the complaint, and to echo some of what's been said, but I think it's very important, these debates about facts or questions that we're discussing, that's for the trial next week. I mean, on its face, we are to presume the facts we brought forth in the complaint and in the motion are true. And it shows that there is a clear and present danger of children and teachers and support staff in our school system that violates Article 9, Section 1A of the Florida Constitution. And the idea that a governor or any executive under the governor's branch can act outside of the Constitution and put children and teachers in harm's way due to a pandemic or any reason flies in the face of what a constitutional government means. And that's why, and I think it's important for us to remember from our perspective that we have great respect for the union and their efforts, but we are a separate case that was brought forward by a group of concerned parents and teachers. And on that end, Judge, the reality that we have this impending issue, we shouldn't force, as it's been said, but I want to make sure it's clear, our client, specifically the plaintiff, is in a difficult position of choosing whether or not to pursue her career and provide for her family or risk her health and well-being. And those are questions that should not be made and should not be forced. And there is no hypothetical in the situation, Your Honor. So those are specifically the things we want to make sure that are clear. The other thing is in regard to Mr. Wells, in regard to the standing of Miss Belfour, who we also represent, who's a parent of 3 children in Orange County. I think there's 2 issues there, really. One is this issue about whether or not she has to go back to school is unclear. It was just announced yesterday that Orange County is in fact now having a new meeting to decide what to do based upon a new medical advisory panel. Part of what we're looking to do on behalf of all parents in Orange County and throughout the state is for them not to live in fear of what could or could not happen. That's part of this injunctive relief we're seeking, or I'm sorry, declaratory relief we're seeking for you as the judge to order the executive branch through whatever proxy they decide that it has to comply with the Constitution, providing schools that are safe and harm-free. Even though this isn't a factual hearing, it's important to note, since Mr. Wells brought out some things from his clients, that Mr. Corcoran just 2 days ago at the White House mentioned that he believes by the end of September, that we'll have 80% of schools be filled with children. So the idea now that we don't think that schools are tracking under what the governor and the executive branch thinks going to happen in terms of having very full systems or very full schools that could lead to another level of the pandemic and a level uptick, all of things we would want to argue before you to prove at this point the current position that we're going into of opening up our schools, whether partially or fully, depending on the county, needs to be in compliance with the Constitution, which it's not. And so I would, just, give it back to Mr. Meyer for any questions, Your Honor, or if you have any questions for me, I'd be happy to answer them as well.
And Your Honor, let me just add a little bit again. As of yesterday, 43,828 children under 18 have been diagnosed in Florida with COVID-19. 531 of them have been hospitalized and 7 under 18 have died. That's as of yesterday. Since just August 1st, less than 2 weeks ago, I guess just 2 weeks ago, 6,800 children under 18 have been diagnosed with COVID-19 and 148 have been hospitalized. This is an upward ramp, Your Honor, and a July 6th emergency order, frankly, is not adequate to consider the ongoing, continuing dilemma that school districts are facing. Local school boards who wish to take some actions to submit a plan to delay the brick and mortar opening and instead substitute learning through computer instruction have been thwarted in their ability to do that. Hillsborough County submitted a plan to do just that. And the reaction was, you can't do it. You got to make a school by school determination. And we're going to send not medical experts down, but the Commissioner of Education down to decide which schools can open and which schools can't open, despite the fact that the Hillsborough County School Board had conferred and consulted with medical experts in reaching their own decision. The same kind of dialogue, Your Honor, is going on all throughout this state. And school districts are being pressured with this zeal to open schools without regard for the continuing expansion of the pandemic and without regard for a non-arbitrary and capricious mechanism for determining which schools will open, when they'll open, and how they'll open. Your Honor, the complaint states a cause of action. The motion to dismiss should be denied, and we should move forward, hopefully resolve this through a mediation next week. And if not, we can consider some of the issues that Mr. Wells wants to inject when the temporary injunction hearing unfolds.
Okay, Mr. Wells. Yes, sir. You're muted there, Mr. Wells. All right, still muted. Nope, still muted. You're still muted there, Mr. Wells.
Am I unmuted now?
Yep, you're unmuted. Yes, sir.
Okay, thank you. I apologize. Technology is not my first love or first passion. We understand that we're here on a motion to dismiss, and our arguments as we've written them and made them here today, we've accepted their facts as true. We've accepted their allegations and their challenges. I find it both ironic and I don't know what the right word for it is, that someone would argue that in a motion to dismiss, the only motion is your failure to state a claim. So there is no motion to dismiss for improper venue. There's no motion to dismiss for lack of jurisdiction. There's no motion to dismiss for lack of standing. There's no motion to dismiss for violation of the separation of powers. That's not true. That's an argument to try to kick the can down the road and not deal with these tough questions. These are not unusual arguments. They're unusual in that they don't come up that often because standing, separation of powers, and political question don't come up that often. But we know that when they do come up, the courts have dealt with them on motions to dismiss and have oftentimes dealt with them swiftly. And the fact that there's a declaratory judgment claim, it is not magical. It doesn't wash away the requirements for standing, for not violating the separation of powers or answering a political question. You can violate the separation of powers and answer a political question by what you say in response to the request for a declaration, just the same as if you were responding to their injunctive relief. It is not magical in any shape, fashion, or form. The plaintiffs claim that all they're asking for is a declaration, but the declaration would say that it's invalid. The declaration would say, presumably, you, Mr. Commissioner, must waive the current statutes and make the payments as the plaintiffs wish. So to stand up and say that we're really not asking you to do that, Your Honor, we just want you to say that in a declaratory judgment, I think is just dodging it in a way that doesn't make any sense and isn't fair to the process here today. You were indeed being asked to do all of that, and it'll be up to you to decide whether you can, but let there be no doubt that's exactly what's being asked. And I heard again about Judge Reynolds, and I think we're not doing justice, or plaintiffs aren't doing justice to his thoughtful opinion. His opinion was based on what was in front of him, and he was careful to talk about that. I have no doubt that given his duration on the bench, he tried construction cases. And I suppose Your Honor probably has too. It's nothing unusual for you to have somebody bring a claim for a condominium project that they've violated the building code. There's a standard out there. It's been dealt with back to 1974 when they came up with the Condominium Act. And so it's been out there. It's nothing unusual, no new grounds. And it doesn't come in the context of a question of whether the judiciary, the executive, or the legislature should be doing something. Here, we're not being asked whether the courthouse meets the building code standards or whether a Dunkin' Donut franchise meets the sanitary standards. You're being asked to come in and determine the best way to deal with coronavirus and what is safe under that. And there's no way that this court can address safety under Article 9 without addressing high quality, because that's the exact balancing that the governor and the commissioner have had to do. Balance between the two. You cannot deal with one without dealing with the other. And there's no question that under those circumstances, it is a violation of the separation of powers and a political question. I have to just comment on, I find it ironic that after hearing about the motion to dismiss standard, Mr. Stort and Mr. Meyer proceeded to talk about what's been in the newspaper for the last few days. There's no question that what's out there is absolutely hard and absolutely difficult. It's a hard and difficult case for the commissioner and for the governor. And if this court chooses that this is an improper invasion of the separation of powers, it's being asked to go where it shouldn't. If this court chooses that it should not answer the political question, it's not abdicating anything in the face of these claims. I was struck by the arguments because I just recently reread the Supreme Court opinion in Citizens, and Justice Parenti basically called out the majority saying, you're punting and you're doing wrong for all of these disadvantaged students who are being forced to be in this improper, not well performed educational system. And the response of the majority was, no, we are exercising the hard decisions that we're asked to do based on the law. And we find that it's a political question. Your Honor should find that same thing too. The case should be dismissed. Thank you.
I'm denying the motion to dismiss. As each side has pointed out, on a motion to dismiss, I'm required to accept the allegations of the complaint as being true. By denying the motion to dismiss, I'm not in any way saying that the plaintiffs are going to be successful with their case. They still have the burden of proving their case, and based on the procedural status at this time, I'm denying the motion to dismiss. I'll get a written order out on that. This is a case that cries out for the parties to get together at this mediation and come up with an agreement. It's a very complicated case. I know that. And between the governor and the education commissioner and the plaintiffs, I'm confident that if y'all work really hard, you can do that. And I'm very hopeful that you can. It's a case that really needs that very badly. But in the event that you can't do that, we'll have the hearing next Wednesday and Thursday, and we'll start at 8:30 on Wednesday morning on that. Anything further we need to address today?
No, Your Honor. Just by way of report, will tell you that as soon as we got off the hearing yesterday, I reached out to the clients and to my partner, George Lemieux, who agreed to step in and handle the mediation while I prepare for this. And he's been briefed, and I know he's reached out, I think, to Mr. Coffey, and I forget if it's Mr. Richard, who else is doing that, and they're already working on a mediator. So that's proceeding forward.
Great. And just let me know if you need me to get involved in that. Hopefully not. Okay. Anything further today?
Nothing further, Your Honor, from the
No,
plaintiff.
Your Honor. Thank you for the time and doing it so quickly.
Judge,
Yes, sir.
we have one thing, Your Honor. We filed a motion to amend the complaint that the defense doesn't, or the state defendants have no objection to. I'm waiting for an order, I've sent them a proposed order, waiting for them to get it back, but I'd just be asking that you consider that. It had no change on any of the merits or argument. It's just adding 2 more plaintiffs to the case who are both teachers. Your Honor.
If there's no objection, just get that to me, and I can get that entered.
Thank you, Your Honor.
There was no problem, Your Honor. We just got the proposed order and had a couple of issues with it, but did not attend to it last night because I was preparing for this.
Right.
Totally understandable. That's why I didn't want to bring it up until after. So thank you, Your Honor.
And Your Honor, the plaintiffs will be bringing a motion forward as well to interlineate, to add additional plaintiffs as well.
All right.
No, we've not had a chance to look at that, Your Honor, and have no opinion, at least at this time.
I appreciate that.
Thank
Okay,
you.
Hearing there's nothing, Ms. Martin, yes, ma'am.
I'm the court reporter, obviously. If I put my email address in this little chat box, can every one of y'all email me and tell me who you represent and all of that stuff, please?
Yes, ma'am.
That you were present. Okay, I'm going to put it in the chat box.
Okay, if I can figure out the chat box, absolutely.
It's down at the very bottom where you mute and you
Thank you.
link your.
Okay.
I might not be able to.
Billy,
Okay.
Iverson is here.
Okay, y'all take care of that. Nothing further than court's adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
Can all y'all see that?
Yes, ma'am.
Nate, can you get that?
All right, I'll get it to you right now, Ms. Martin. Thank you. Be well,
Thank
everybody.
you all very much, everybody.
Thanks, y'all.
Thank you.
you. Be well,
Thank
everybody.
you all very much, everybody.
Thanks, y'all.
Thank you.
Thank you. Be well,
Thank
everybody.
you all very much, everybody.
Thanks, y'all.
Thank you.
Thank you. Be well,
Thank
everybody.
you all very much, everybody.
Thanks, y'all.
Thank you.